Morning, everyone. Happy 4th of July. It's Rick. You need to contact me for help you get out of this situation you're in called child support, which my research and experience has led me to believe that it's fraudulent, and the methods they use to ensnare you are fraudulent. Okay, and my email is rick0327@me.com. I made a mistake the other day. Joe's channel, if you want to learn how to avoid the court's jurisdiction when you're before a judicial actor, you want to object, and you need to object and clarify the evidence that the judicial actor is relying upon to deny whatever you're objecting to. It's ethical anarchism articulated. Good stuff. He's a good guy, Joe. He's a piece of work. He's a very bright guy, very good at what he does, and he's a regular guy just like me. I just got tired of the nonsense and started a channel, and people got what he was talking about, and that's how you relate to people. People identify with your struggle, identify whatever points you're making. Same thing happened to me. A little over a year ago, I started doing this, and here I am, 3,400 subscribers later. People identify with my struggle. They identify with what I'm saying. And I have a pretty good idea what I'm talking about. There's a website, if you keyword it, it's NCSL. It's National Conference State Legislatures. So what it is the state legislators, all 50 states, they discuss certain certain laws, so legislative acts. And in April, they did child support, administrative versus judicial. Steve Willing found it one night, trolling, but not that kind of trolling, searching. And what I found by looking at that website, they have it like a chart of all 50 states, and they're all judicial. But some states, they use administrative as well. Now, what I found with the administrative is there has to be some type of agreement, which makes sense. Because administrative, they need your permission. They need an agreement. Okay? But what they do is they trick you. That makes sense why some states use administrative and judicial at the same time. Some states use administrative, they claim, well, this is the reason why they do expedited processes under 45 CFR 303.101. And it claims, well, it saves a lot of time in the courts, that due process. That stuff is just so damn timely. It takes so much time. So you know what we're going to do? We're going to make up some bullshit, Code of Federal Regulation, Code of Federal Rules, and, as long, and we'll have, subsection C. So long as you're following due process, it's okay. All right? That's how slick they are. So they say you have to follow due process. Well, if you're following due process, you have no reason to use 45 CFR 303.101. It's unbelievable, the nonsense, and that's what it is. They got us jumping through hoops. But what I'm doing is I'm looking for all the shortcuts. Okay? I'm not worried about de-establishing paternity. If the order for support is void, what do I care about paternity if the order is void? Right? So don't worry about that if the order is void. Now, let's say you're one of these people, and there are a lot of you. You have a support order issued by one of these fake judges or non-judicial persons. That is void. New York State. Now, New York State is a judicial, for child support is judicial. Okay? So, how many of you that are subscribed to me, I'm a New York guy, and your support order is void. Okay? So, that's the reason why I've at 439 of the Family Court Act is the powers of a support magistrate. There's two paragraphs, a couple, it's long and lengthy and bullshit, illegal mumbo jumbo nonsense. And here's another thing, I keep saying she because I had a she. Support magistrate is supposed to be, if you have an agreement from another state, an order from another state, or they're establishing an order, but the mother or the children must be receiving public assistance. Okay? How many of us, like myself, was divorced and I got ensnared in that scam? And of course the lawyer, I had a lawyer, didn't even think about, they were just in there arguing with the arms, standing there with our arms crossed. And remember, a controversy, the more complicated a controversy, the more money. It's what do lawyers call it? A winner. They call that a winner because they can make more money. Not about winning the case. It's a winner because a lawyer told me this on YouTube. And a loser is a case where they can't make any money. So let's just say you have a slam dunk case. A lawyer won't take it because it's a loser. I can't tell you how many lawyers I reached out to, as I'm sure many of you have. And you know what? Maybe you did, and and they didn't get back to you. You want to know why? Because you probably explained the case. It was probably cut and dry for a lawyer. Cut and dry. It's not cut and dry for us because we're not lawyers. So we go in there right away. They're going to be, contemptuous towards us because we're not a legal professional. Thank God. Okay? So that's why attorneys won't answer you. That's why they didn't get back to me. So you just see what we're dealing with. So a lawyer would never dream about tackling a support order the way I am, that it's void. It's a void order. A lawyer you'll probably never hear out of a lawyer's mouth, quorum non judice. Not possible. Okay? They're probably forbidden. I've done my research, and you go on these YouTube pages and message boards, and what's common is I got a book, and I'll review the book, written by a couple of authors who are just like us, fighting the system. And in a passage in one of the chapters, they'll say that a lawyer will not dare about bringing up jurisdiction if they want to continue to make money in that state. Okay? I mean, I'm paraphrasing, but that was the gist of what they were saying. Okay? And think about that for a second. So, let's say your whole case it comes down to jurisdiction. Let's say the case could be decided and dismissed like that, just on base of jurisdiction. But it's not going to happen, because if your attorney is concerned about practicing law in that state, in that courtroom in the future, it's not going to happen. Sad. That's why we're better off by ourselves, as I've always maintained. All right? So, okay, I'm covering two topics also. I got Joe's website, YouTube page wrong. It's Ethical Anarchism Articulated, formerly known as Cop Watch Hawaii. Very good guy, teacher, very good stuff. He's very good at how to object in a courtroom and a bunch of other things. He's a student of Mark Stevens. Okay, and I like Mark Stevens as well. I'm like a guy. I was listening to Joe before I ever started a channel. I'm like, I borrow from everybody. Okay, plus I take my experiences. I'm like, I borrow from this, I borrow from that, and I figure out what I can use and what I can't use. I figure out what I tried to use, it didn't work for me, and then what worked for me, then I try and pass it on to you guys. I'll put it in the description box. I'll put Joe's again in the description box, and National Conference of State Legislators, NCSL. Okay, it's good stuff, and it also show you how to tackle your problem. So if your state is using administrative procedures and you have a support order, you could go at the support order by using administrative dismissal. If it's judicial, well, they're all judicial, but some states are strictly judicial. New York is strictly judicial. Looking at it, I would say that I think it was like 66% of the states are strictly judicial, and 2/3 of the states they're using both. Okay, and that'll show you how to go at them. All right, so I'm just gonna shut the video down real quick. Again, if you need to reach me, it's rick0327@me.com. Enjoy the rest of your day.